Hello, this is Jim Maroney again. In this opening session for Missouri bankruptcy exemptions, you undoubtedly think it's strange that I'm opening it up with a line graph. There's a reason for that. In the 2005 Bankruptcy Amendments, you know, I've mentioned to you before in different parts of this series that the bankers and the credit card companies and the three automakers in this country, they bought and paid for our congressmen and senators to get that law passed. They paid over $100 million in political contributions. One of the paragraphs that they slipped in was what I call the 730-day rule. Here's where the rule works. When we file your bankruptcy petition on a particular date, if you've lived in the state of Missouri, or any state, for the 730 days before filing date, then you're going to use the law of exemptions that applies to the state where you live. And that rule is going to apply to most of you. However, if you have lived in 2 or more states during the 730 days before your filing date, then we're going to look at the 180-day period prior to the 730-day period. And you will use the law of exemptions for the state where you've lived the greatest number of days during that 180-day period. Now, there's a problem with that. Let me give you an example. Let's say that you have lived in Missouri and another state during that 730-day period. So you know that you've got to go back to the 180 days to see where you've lived. So you therefore look up the law for the state where you've lived the greatest number of days during that 180-day period. Well, when you read that law, its exemption statute limits its application to residents of that particular state. So here in Missouri, the trustee is going to look and say, well, you can't use that exemption statute from that other state because it's, by definition, the way it's worded, it's limited to residents of that state. You're no longer a resident of that state. Well, the federal statute, the Bankruptcy 2005 Amendments, it has another paragraph that says, well, if you go through the rules and you can't use any exemption from a state, then use the federal exemptions. So you can see how a lot of attorneys and a lot of clients don't know this rule and they've been trapped. I want to give you a recent case that came out here of the Western District. This lady lived most of her life in Joplin, Missouri. And she sold her home in Joplin and moved to Kansas. And when she moved to Kansas, she almost immediately bought a home. And she put down $60,000 down payment on that home. Well, she ran into financial problems and she decided she needed to file bankruptcy. So she went to see an attorney in downtown Kansas City, Missouri. And he said, well, lady, you've got nothing to worry about. You live in Kansas, and they have an unlimited homestead exemption. So I'll go ahead and file your bankruptcy petition in Missouri, even though you're a Kansas resident, and we'll just put down in the petition that you have an unlimited homestead exemption. Well, the trustee, when he found out that she'd lived in both Kansas and Missouri during that 730-day period, he looked at her residence history and said, well, now wait a minute. During that 180-day period, before the 730-day period, you lived in Missouri. So you're going to have to use Missouri exemptions. Well, Missouri homestead exemption is only for $15,000. So in that case, the trustee said, what we're going to do is I'm going to sell your home. I'll give you your $15,000 cash for your Missouri homestead exemption, and the remaining $45,000 that we get from selling your home, that's going to be paid to your creditors. Well, she fired the lawyer, and she got a new lawyer, and the new lawyer came into court and said, Judge, you know, very clearly this lady had an incompetent lawyer who didn't know the rule. So what we'd like to do is we'd like to dismiss the petition. And the bankruptcy judge said, no, I'm not going to let you dismiss that. We've got $45,000 of cash available to pay creditors. and we're going to go ahead with the bankruptcy so that those creditors get paid. Now that's tragic. That is absolutely tragic. The problem comes up is that there's so many law firms that the lawyers and even more frequently the paralegals, they really have never read the bankruptcy statute. That law firm has bought computer software from a vendor that does bankruptcy petitions. And if that software doesn't ask them the question, they don't know to ask. Years ago, when I started, I was licensed in 1975. We didn't have computers then, and we drafted petitions using typewriters. I'd load the petition in, and I'd use carbon paper, and I'd have to make 4 copies, as I recall. If you made a typographical mistake, you had to get the eraser out and erase the original and all 4 copies. Maybe some of you are old enough to remember those days, but the benefit of it was every petition that I did, and not using computer software, I understood exactly what was going on. Well, it's the same way today. I can draft a bankruptcy petition without ever using computer software. I use computer software because of its convenience, but when it's wrong, I know it's wrong. And I hope that you will either hire me or hire some attorney that feels the same way. You don't want to get trapped in rules like this. Before I conclude this 730-day rule, let me say this to you, and it's just peripherally irrelevant, but I want to mention it to you anyway. Corporations can file their bankruptcy petition anywhere they want to. We recently had General Motors and Chrysler file bankruptcy. Well, they both filed in New York. Well, they've got very few employees and they've got very few assets in New York. Why didn't they file in Detroit? Well, the bankruptcy judges in New York are big business, cater to the big business people. And because of that liberality for the rules for corporations, corporations can file their bankruptcy petitions wherever they want to. As an American, I'm irate that we have a double standard. We've got one rule of residency for corporations and the big money people, and then we've got another set of rules for you and me and the rest of us. That's not good for democracy. We all need to be treated equally and fairly. So I hope that at some point you might even drop a note to Claire McCaskill and our congressman and say, hey, what's the double standard for? We have exalted corporations in this country. The bailout that we just had, where all the money went to the banks and the investment houses, what'd you get out of it? You were told, well, hang on, there's a lag before employment improves. That's all bullshit. That doesn't mean anything. So this rule, every time I ask a client about the residency for their 2-year, 3-year period before filing date, I have to ask so that I protect them. But every time I ask, in the back of my mind, I think of those corporations being able to file everywhere that they want to, and it infuriates me. What a bunch of crooks we've got in Washington. You can get mad at the Republicans. We had President Bush in office, and we had a Republican Congress when that 2005 law was passed. But that wouldn't be accurate to get mad at just the Republicans. The biggest dollar beneficiary of these political payoffs, these contributions, was Joe Biden, our vice president. So Democrat, Republican, they're just, to me, at age 62, I'm 62, the Democrats and Republicans are just different species in the same rat family. They don't care about you and I. So I'll quit pontificating, but watch the 730-day rule.